serious echo here. Was it the breakfast? Okay. All right. Well, once again, good morning. Welcome to the August 13th, 2024 regularly scheduled land use meeting of the Hillsborough County Board of County Commissioners. Would everyone please rise for the pledge and invocation given by our chaplain, Commissioner Cameron Cepeda.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Heavenly Father, we come before you this morning with praise and thanking you for your great love and your mercy. You look from all the sons of men. You look upon. We pray for peace in the Middle East and protection for all the innocent people that have been affected by war. We pray for protection over all of our men and women that are serving in the military. We pray for protection over our law enforcement, first responders, and firefighters. And we pray a special blessing over Hillsborough County, the state of Florida, and our great nation. And we pray for peace throughout our land. And we ask you to bless this meeting in your holy name. Amen.
Mic check, test 1 2, test 1 2. Check 1 2, check 1 2, 1 2, 1 2, 1 2, 1 2, 1 2. Test 1 2. Test 1 2.
Good morning and welcome back to the Board of County Commissioners, our regularly scheduled land use meeting. I apologize for the technical difficulties we've experienced this morning. Hopefully they've all been resolved. With that, I'll hand things over to Mr. Grady to go over the changes to the agenda.
Good morning, Commissioners. Brian Grady, the Hillsborough County Development Services Department. In addition to the withdrawals, continuance, and remands on page 3 and 4 of the agenda, we do have a number of changes to the agenda. The first change is on page 8, item B9. This is the item to authorize the county's attorney's office to file a petition for writ of certiorari with the Southern District Court of Appeal in the matter of GL Acquisitions Corporations Incorporated versus Hillsborough County, which arose from the board's denial of RZPD 23-0132. Commissioner Wastall has requested this item be pulled from the consent agenda section of the agenda. Second change is on page 12, item G1. There is a typo in the applicant's name, and that's being corrected. And then on third change is on page 13 of the agenda, item I2, LDC 24-0169. The applicant is requesting this item be continued to September 10th, 2024 Board of County Commissioners Land Use Meeting at 9 a.m. And the final change is the off-the-agenda item, special appearance by outside counsel Samuel J. Solario of Lawson Huck Gonzalez to discuss the status of the school board of Hillsborough County versus Hillsborough County and Craig Latimer, case numbers 24CA5947 in the attached resolution that was attached to the addendum. That item will be taken up following the discussion of the pulled item B9. And that concludes all changes to the agenda.
All right, can we have a motion to approve the changes?
Move approval.
Second.
Motion Commissioner Myers, second Commissioner Cohen. Please record your vote on the changes to the agenda.
Motion carried 7-0.
Okay, item B9 has been pulled for a separate discussion and vote, but at this time, can I have a motion to approve the remainder of the consent?
So moved.
Motion Commissioner Cohen.
Second.
Second Commissioner Myers. Please record your vote.
Motion carried 7-0.
Okay, for B9, does staff need to say anything or? Good morning, Cameron.
Good morning, Mr. Chair. Good morning, board members. Cameron Clark, Assistant County Attorney. This item is just seeking board authorization to file a petition for writ of certiorari with the Second District Court of Appeal in the matter of GL Acquisitions Corporation, Inc. v. Hillsborough County. This arose from the board's denial of rezoning PD 23-0132. This, you'll recall, was the Pebble Creek Golf Course. This application, I believe, was before the board a little over a year ago. We believe there's an appealable issue we can proceed with if it's the board's desire to do so, and that's what this item is requesting to do. This item includes only the order that was issued by the judge in this case because in what's called a second-tier petition of writ of cert, the only matter the appellate court focuses on is the order of the lower court, as opposed to focusing on the facts of the application, which is what the circuit court's review standard was. I can take any questions. I believe that it would be best to see if there's anyone able to comment on this at the time before board discussion, because I know this was on the agenda, Commissioner. It's not a public hearing, though, just to be clear. Thank you.
All right, thank you. Okay, so County Attorney's Office recommendation, it's not a public hearing, but would anyone like to speak to this item here? Okay, Commissioner Wastall.
Thank you, Mr. Chair. First, I've already expressed this to the Attorney's Office. I'm very displeased that this was put on consent. It should have never been put on consent, and I shouldn't have had to pull it. I've already confirmed that it's out of the norm for us to even be filing this appeal. We don't do it typically. I'm frustrated that I didn't even know the only other time seemingly that we've ever had one of these get appealed, and it was also on consent. I didn't even know it was on there. It was very early on into my time here on the commission. I voted no on this because these are quasi-judicial hearings. These are much different than other appeals that we might do legislatively. These are very clear. There's restrictive guidelines on place. Myself and one other commissioner were very clear that we didn't think that we met our quasi-judicial capacity and requirements of meeting competent substantial evidence for anything other than an approval. The judge has went on to agree with myself and that other commissioner. Specifically, they said that we cannot deny rezones on the basis of our opinions on whether or not an owner of a golf course has good sense and common decency. That's a quote. They also went on to iterate the fact that we can't be making quasi-judicial decisions based off of the amount of people that are within an audience. And they have went on to agree with us that there is no competent substantial evidence for the determination of a denial, and that they have quashed the original denial. My position was reaffirming that it should have gone through the first time, and I still have that position. I wanted this poll to just make those comments so I can make my voice heard, that I do not believe that there's anything has changed and that any result will change by moving this forward. So thank you very much.
Commissioner Cohen?
Commissioner Wastall, I was the other commissioner that agreed with you on the merits of this matter, and for that reason alone, but also for many of the things that you cited, I'm going to be also voting no.
All right, thank you. Let me make a couple quick comments, and then I'll entertain a motion. While appeals do not happen frequently, it's not uncommon, like as Commissioner Wilson just stated, the very last one that we, land use a recommendation of overturning our decision that we came in front of us, the County Attorney's Office recommended that we appeal the case. It was actually also in my district in a DIBS matter. And then it's my understanding on any type of appeal cases when there's a supermajority vote that it's also not uncommon for it to be placed on the consent agenda. And be careful not to enter any new information in the record, as Cameron alluded to, but I do want to point out a couple things. Two things have changed since the board voted 5-2 to deny the petition. Number one involves Live Local. Adam is, and I mention this because the applicant had referenced that during their initial presentation that this would potentially apply. Adam has previously stated that this parcel would not qualify, and if it came in front of us, he would not grant any permit request. However, thanks to Commissioner Wostall's leadership, we are changing our LDC, further strengthening our position with respect to Live Local's ability to apply here. And then secondly, it's become apparent that this case has countywide implications. And what I mean by that is other neighborhoods are looking at this board to see if we're going to stand behind our neighborhoods or if we're going to cut and run. Make no mistake, by and large, Pebble Creek, it's not unanimous by any means, but by and large, the community is not in favor of this development. I'm going to read my comments from the initial meeting, so it's not anything new. Of the 1,363 emails that we received, 1,090 opposed the request, which is 80%. According to the County Attorney's Office, when broken down by individuals who are part of the record, we've heard from 446 people, of which 388 oppose, which representing 87% in opposition. Now, in advance to today's meeting, the last few days, we have received 140 emails begging us to appeal the decision, and I believe my numbers are accurate. 58 have come in asking us to support the lower court's ruling. Again, 71% have asked us to stand with their community. We've also received 18 emails from Sun City Center and 11 from Plant City asking us to stand with Pebble Creek. Plant City has fought the same issue for years. I'm sure Commissioner Miller is quite aware of it, more so than I am. And Sun City Center knows that they're likely next to face this same situation. Like the County Attorney's Office, I do feel there's a basis for appeal. Again, I don't want to say anything new, but I do want to say one thing with respect to the lower court's ruling. And I want to point out that I know this judge. He lived in my old neighborhood. But it's as if he did not read the basis for my motion. I'm not going to read the entire order, but, and Commissioner Wostel referenced this, he says in his order, the board's decision was based in part on the belief that the president of Ace Golf lacks good sense and common decency. It also goes on to say the board's decision was also based on the number of residents who gave testimony and wrote letters opposed to the change in zoning. However, if you actually read my motion, it's not based on any of that. My motion to deny, and I'm going to pass the gavel to Commissioner Myers, is based on the fact the application is inconsistent with the comp plan, specifically as outlined in Objective 16, Neighborhood Protection. It states the neighborhood is the functional unit of community development. There's a need to protect existing neighborhoods and communities and those that will merge in the future. To preserve, protect, and enhance neighborhoods and communities, all new development must conform to the following policies: 16.8, 10.10, as well as 1.4, 8.1, and 8.2. And while, yes, it's true, myself and other commissioners referenced the overwhelming opposition to this, that simply was not the basis for denial. And the lower court just simply did not even, I don't even think he read it, quite frankly. So with that, I'm going to pass the gavel to Commissioner Myers, and I hope the board will stand with the residents of Pebble Creek, Sun City Center, and Plant City, and will continue to fight this unwanted development, not because they don't want it, but because it's inconsistent with the comprehensive plan. So I'll pass the gavel and make a motion to approve staff's recommendation.
Okay, I don't see anyone else in the queue. Please record. Commissioner Miller, you trying to speak? Okay.
I just wanted to say I'm in a very unique position, having been appointed midterm in the middle of this, but I will never be in support of development on a golf course, both in Plant City and Sun City. They're both in my district, and I'm going to defer to the commissioner that Pebble Creek is in his district.
Okay, thank you.
Need a second?
We need a second. Do we have a second on this motion?
I'll second it.
Okay. Seeing no one else, please record your vote.
Motion failed, 3-4. Commissioner Cameron, Cepeda, Cohen, Myers, and Wostel voted no.
Mr. Chair,
Yes.
I will do, as a prevailing side, I will do a motion, I believe a motion to reconsider at this time is appropriate. And I think that we should restate the intent of the original motion.
Okay, we have a motion to reconsider by Commissioner Wostel. Do we have a second?
I'll second only because if you want to say why you are making a motion to reconsider, do you think the motion was misunderstood?
I believe that I'm more than happy with prevailing on a side, but not under inappropriate pretenses. I believe that there is a vote that was not intended to be a no. If the chair could just simply restate his motion in the intent.
Yeah.
I think I misunderstood I'm
Same.
sorry.
Yeah, the motion was to approve the appealing the decision. And so I think
The
Commissioner...
motion was to approve appealing the
Yes,
decision.
and I
Okay.
think Commissioner Wostel is accurate with his assessment of the board's vote, and that's why he's, has a courtesy, making the recommendation to reconsider the vote, and he can do that since he was on the prevailing side. So we need a second by someone that's on the prevailing side.
Second.
Okay, second, Commissioner Cohen, please record your vote on the reconsideration.
And then we come back and vote again? Okay. I think I'm going to get it right this time.
Motion carried, 6-1. Commissioner Cameron, Cepeda voted no.
Okay, so now again, that's okay. Now I'll pass the gavel to to Commissioner Myers, and again, make the motion to approve the county appealing the lower court's decision.
Okay.
So that was my motion. Commissioner Miller, do you second it? Okay, Commissioner Miller, second.
Commissioner Cepeda, you trying to say something?
Yes,
Turn your speaker on, please. Thank you.
yes on that last one.
If you can change the last vote to 7-0.
Yes.
Okay, thank you. Okay, so we have,
Mr. Chair, I'm just going to do a parliamentary inquiry at this point, just because it's such a contentious issue. I don't know if it's Mr. Gormley, who's the parliamentarian, since we don't have Mr. Vernsdale, but simply to reiterate that in this situation, a yes vote is to affirm that you would like to appeal this. A no vote is if you would like to agree with the lower court. I will be voting no.
Yeah, and Commissioner, I can speak to that. That's correct.
Thank you.
Thank you for the clarification.
Okay, so it's no on appeal. Okay. Seeing no one else in the queue, okay, please record your vote. Okay, I hope I got it.
Motion carried, 4-3. Commissioners Cameron, Cepeda, Cohen, and Wostel voted no.
okay, thank you. All right, this time, if anyone plans on speaking this morning, if you would stand, raise your right hand so the clerk can swear you in.
Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated.
All right, Cameron, vacations?
Commissioners, I believe you're going to take
I'm
up
sorry.
off the agenda item first.
Yeah, my mistake. Yeah, out of respect and courtesy to our outside counsel, we're going to take up I-2. Staff need to introduce that item.
For the record, the next item would be the off the agenda item to hear from the special counsel, Samuel J. Solero, regarding the status of the lawsuit between the School of Hillsborough County and Hillsborough County.
Good morning, sir.
Thank you for having me. So you have before you a resolution that was prepared by the county attorney's office with our input that does kind of two fundamental things. The first is it votes to to approve the placement of the school board ad valorem millage on the ballot. And then the second is it provides that approval ceases to be effective should the second district either reinstate the automatic stay pending appeal, otherwise stay the order pending the appeal, or reverse the order on appeal. The headline is I'll recommend that you vote to adopt that. I just figured I'd give you a little background first on where things currently sit. On Friday of last week, we filed a notice of appeal from Judge Peacock's order directing this board to place that measure on the ballot. The school board immediately filed a motion to lift the automatic stay that would have obtained to the county in that circumstance. We filed an opposition on Saturday. Judge Peacock rendered an order denying or granting the motion to lift the stay on Monday morning within a couple of hours. We filed an emergency motion in the Court of Appeals to lift or to review that order, that is to say to review Judge Peacock's order lifting the stay, or in the alternative to expedite the appeal. Yesterday afternoon, we got an order from the Second District Court of Appeal which says that, one, the school board's got to respond by noon today. So that at that point, they'll take whether or not they review the order lifting stay under consideration. And then second, they told the parties to be prepared to move fast. So I think we can expect at a minimum an expedited briefing order. Where that leaves things currently is you have a mandamus order from Judge Peacock entered on August the 2nd that directs this board to meet and approve placement of the ad valorem millage on the November 2024 ballot. That order is not at present stayed. Because that order is currently operative and unstayed, and this is the time you have to consider it, my recommendation would be you vote to approve, understanding that that approval ceases to be effective. Should the second district come in with an order, say this afternoon, and say, you know, we've reviewed this order and we are reinstating the stay. If there are any questions?
Could you state your name for the record, please?
Oh, Samuel J. Solario, Jr.
Thank you.
Thank you.
Thank you. Commissioner Wostel?
Thank you. I think that everyone else should support him, but this is a hill that I'm going to die on, that I do not believe that a judge can order duly elected officials and violate their First Amendment right and dictate whether or not they should vote up or down on an item. It's the only reason I will be voting no today, but I believe that everybody else should vote to support it.
Commissioner Kemp.
Great irony there. As you all know, I don't support this appeal, and neither did my Democratic colleagues. This is all based on a 4-3 vote, and I'll just remind everybody the basis, that Florida is 50th in the nation in teacher pay. I'm just extremely frustrated that a Republican majority on this board has hired a law firm for up to $50,000 to do work our county attorney was fully capable of doing. The hiring was done suddenly without notice last week after advertising to the public that the appeal would cost only $300. Now it's thousands of dollars that we're into for this firm. Judge Peacock's order makes a great deal of sense. I don't think this appeal is going to be successful, so we're wasting more money no matter how you look at it. I'm also concerned that the divisive position this board has taken is going to discourage support for our own CIT referendum for dollars that we really need. So we can save face by bringing this to an end. Obviously, we'll have to pay the lawyers for the work they've already done, but I'm going to make a substitute motion right now to withdraw this appeal and pass a clean resolution. Simply just put this on the ballot, let the voters decide like we should have done months ago.
Point of order.
We don't have a motion on the floor right now, Commissioner Kemp. So currently there's not a motion on the floor.
Okay, well then I will wait until there is a motion to do the substitute.
Okay, Commissioner Cohen.
I just want to address the issue of voting to follow a court's order. To me, you know, I've heard some of these arguments about separation of powers and all these things, and I just think that this is a fundamental misunderstanding of the way that our system works and the way that the law works. And in my view, when a board has been issued a writ like this one from a circuit court judge, there is absolutely no discretion given to us as to whether or not we should vote to follow it or not. And you know, when I was on Tampa City Council, we had a very similar situation to this. I've never seen it happen here, but at the time, it was involving a land use decision, and it was in my district, and it was something I didn't want to vote for. But it was made very clear to me that not only do I have a responsibility to follow the judge's order, but as an attorney, I believe that I could be subject to a bar complaint if I were to vote against an order from a circuit court judge. So I just don't think that that is a responsible option for a board member to take.
Commissioner Woolston.
Thank you. To that, just as you already know that as an elected official, you can't be held accountable in your legal capacity unless you're up here giving legal advice. And land use decisions are quasi-judicial. They are far different than what we're dealing with here, which is legislative. There's a huge difference between our judicial capacity that we sit in land use meetings and a legislative capacity, which is the school board tax. Those are not one and the same. And just before, Mr. Chair, I'll remind the other commissioners before any substitute motions are made that it must present a different outcome than the original motion passing or failing would present. So the one that was mentioned earlier would not. So I'll just wait till then.
Okay, I do have a question, I guess, for the outside counsel. It appears from the presentation that Mr. Brazel gave in front of us and then our brief conversation last week that things have kind of played out the way we expected. Is that a fair statement?
More or less, yes, that's correct.
Okay, and then based on your recommendation, I don't know, maybe we should, get all into handicapping, but what do you feel is the likelihood that the appeals court will take up one of the, I guess, options, if you will?
When you mean options,
As far as stay, the stay or the, making a ruling?
Yeah, so I think it is very, not to get into Harry Potter analogies, but trying to divine a two-sentence motions order is a little bit like divination. So I think what you can say with certainty is they think the motion states a preliminary basis for relief, like they don't think it's silly, otherwise they wouldn't have ordered a response. The second thing I think you can say is they think this is important enough to fast track because they've telegraphed that we're going to fast track this. In terms of what the outcome is going to be, is it going to be stay and fast track? Is it going to be just fast track? Is it going to be something else? I think it's just very dangerous to predict on the face of a two-sentence order. What I can say is, having had some time to get familiar with the briefs and the case, I do feel very strongly about the argument on the statutory text. Like, I think that is a solid and meaningful argument, and I think that's something that, you can see people being interested in. It's a statutory question of first impression in the Court of Appeals. There's no other Court of Appeals that's looked at it before. And and we've got things to talk about on text that I think are important.
Okay. Commissioner Kemp?
Yes, I'll just make a motion straight out to withdraw this appeal, pass a clean resolution, simply just put this on the ballot, as I said before, like we should have done it in the first place months ago.
Okay, so motion Commissioner Kemp, second Commissioner Cohen. I guess, I don't know if this is for Joanne or maybe for Mr. Solario. Clearly, please come forward. So clearly you do not support do not recommend the motion because it would end the appeals process.
I think that motion would effectively moot the appeal.
Okay. Commissioner Wolstel.
Just going to say that I do not support the motion that's on the floor.
Okay. So we have a motion by Commissioner Kemp, second Commissioner Cohen. No other comments. Please record your vote.
Motion failed, 3-4. Commissioner Miller, Cameron Cepeda, Hagan, and Wostel voted no.
All right. What's the pleasure of the board?
Mr. Chair?
Yes.
I will move to approve staff's recommended board motions A and B.
Okay, we got a motion by Commissioner Wolstel for staff recommendation. Do we have a second?
Second.
Second, Commissioner Cameron Cepeda. If no other comments, please record your vote.
Wait,
Oh,
can I just clarify, when you say you're moving staff recommendation A and B, so you're now moving the recommendation to,
I could read it out if you like, Mr. Chair. It's just 2 long paragraphs.
sure.
Okay. I move for approval of the special appearance by outside counsel Samuel J. Solario of Lawson Huck Gonzalez PLLC to discuss the status of school board Hillsborough County versus Hillsborough County and Craig Latimer case number 24CA-5947 and consider adopting a resolution in the form presenting calling an election of November 5, 2024 for a referendum of the school board of Hillsborough County for the school board to levy additional ad valorem taxes for operating expenses in accordance with and as mandated by the order granting emergency petition for writ of mandamus dated August the 2nd, 2024 in the case, with such resolution taking effect immediately upon its adoption and remaining in effect unless and until the District Court of Appeal of Florida, 2nd District reinstates the stay in the case or reverses the order.
second.
Okay, so we got a motion by Commissioner Wolstel, second Commissioner Cohen. No other comments, please record your vote.
I'm unclear again. I'm sorry.
This is just to simply continue the process forward with the appeal that we currently have in place and to meet the Judge Peacock's writ of mandamus unless the stay is lifted. And then, of course, it will go back into regular effect.
Thank you. Just wanted to be clear.
Okay, so we have a motion. Commissioner Wolstel, second Commissioner Cohen. Please record your vote.
Motion carried 6-1. Commissioner Myers voted no.
Okay. Ms. Grady.
The next item is agenda item C1, is vacation petition 23-0006. This is a vacate petition, and Facilities Management and Real Estate Services will present this item.
Good morning.
Good morning. Good morning, everyone. Good morning, Commissioners. For the record, Kathleen Pizzone with Facilities Management and Real Estate Services Department. We've got two vacating items today. The first item is C1. Vacate ID is V230006. This is a petition by East Group Properties LP to vacate a 20-foot wide portion of unimproved public right-of-way known as East Old Hillsborough Avenue, adjacent to Folio 065-057-0100 in Seffner Mango. The petitioner has submitted this request to support the redevelopment of the property for the Tanner East Planned Development Rezoning Project. The proposed vacate area is generally lying south of East US Highway 92 and east of Interstate 75 in Seffner Mango, and contains approximately 17,447 square feet and 0.40 acres. The petition was routed to appropriate departments and agencies, and there are no objections to this request.
This public hearing, anyone like to speak to this item? We have a motion.
So moved.
Motion Commissioner Wostel, second Commissioner Cohen. Please record your vote on C1.
Motion carried, 7-0.
C2.
Commissioners, next item, agenda item C2, vacation petition 24-0005.
Our second item today is vacate ID V24005. This is a petition by CND Rodine LLC to vacate portions of unimproved platted public utility easements lying within Lot 32 through 39, identified as Parcel A, and Lot 17 and Tract B, identified together as Parcel B, within the plat of Peninsula at Rodine Lake at a partial replat. Recorded in Plat Book 146, page 102 of the Public Records of Hillsborough County. This request is made for the purpose of resolving a Parcel A easement, which has been determined to be unnecessary due to an existing duplicate utility easement lying in the northern boundary of the corresponding lots, which serves the same purpose, and the Parcel B easement, which was platted in error. The proposed vacate areas are located east of US Highway 301 and north of Rodine Drive in Riverview, and consists of approximately 5,101 square feet. This petition was routed to appropriate departments and agencies, and there were no objection to the vacation of this portion of utility easements.
This public hearing, anyone like to speak to the item? Our motion?
Move approval.
Second.
Motion Commissioner Cohen, second Commissioner Wostel. Please record your vote. C2.
Motion carried, 7-0.
Thank you.
Mr. Grady.
Commissioners, next item is agenda item E1, PRS application 24-0536. Commissioners, this is a request for a minor modification to a 1.74 acre parcel that's located in the university area north of Fletcher Avenue at the northwest corner of North 20th Street and East 136th Avenue. The PD is approved for 18 multifamily housing units and 16,500 square feet of office, professional services, community space, and accessory retail uses. The request is to make modifications to the site development plan. There will be no changes in development entitlements associated with this project. The changes include removing an access to 136th Street and retaining a building that was shown as previously being removed, and basically relocating of parking and stormwater and related uses associated with that. Staff is recommending approval. I will note for the record that there were in the backup, and in the party of record, there's a letter in the party of record that is not associated with this application, so I just want to note that for the record. Thank you.
All right, is the applicant here? Good morning.
Good morning, Commissioners. My name is Catherine Hartley. I am a certified planner. For the record, my address is 2001 East 2nd Avenue, Unit 6, Tampa, Florida 33605. Staff did an excellent job summarizing the case. It's very simple. We're just taking out a driveway that was actually in where a building that was originally going to be demolished was. We needed to calculate for a little bit more stormwater, and because of that, we had to move the parking around a little bit, and that's it. Thank you.
All right, thank you. Anyone here support the application? Anyone in opposition?
I believe the executive director would like to speak.
Okay.
I think she registered to speak.
Good morning.
Good morning, Board of County Commissioners. My name is Sarah Combs, and I'm the CEO of the University Area CDC, and I'm honored to be here today to request your support for a minor modification to our planned development, the University Area Cultural Campus, as Ms. Hartley just explained. Our community's cultural diversity is one of our greatest strengths, with over 30 languages spoken in our neighborhoods. The Cultural Campus aims not only to celebrate this diversity, but also to provide vital opportunities for inclusion, education, and economic mobility in the growing Uptown University area. This need was clearly identified through several community meetings and surveys over the past couple years, which revealed that many of our residents face significant challenges, included limited education, high employment, language barriers, inadequate healthcare services and access, and transportation disadvantages. In response, it is crucial that we expand both our services as well as our facilities to meet the growing demand of university area residents in their journey towards self-sustainability. The mission of the Cultural Campus is to serve as a navigational hub, linking community residents and local businesses with anchored partners who provide direct programming, services, and economic growth opportunities through a holistic approach. The University Area CDC is committed to following an equitable development framework that not only supports the quality of life for residents, but also supports and embraces the flourishing cultural arts community in the Uptown University area. For over 25 years, the University Area CDC has been at the forefront of driving positive change in the economic, educational, and social fabric of our community through youth programs, adult education, affordable housing, workforce development, and community engagement. We firmly believe that by empowering residents to become agents of change, we improve the economic and social conditions of our community one block at a time. Thank you for your time and your consideration of our request. Your support is truly invaluable as we continue to grow and strengthen our community.
Thank you. Anyone in opposition? All right, can we have a motion?
Move for approval.
Motion, Commissioner Meyer, second Commissioner Kemp. Please record your vote on E1.
Motion carried 7-0.
E2.
Commissioners, the next item is E2, Purist Application 24-0635. This is a request for a minor modification of approximately 8.15 acre parcel that's located on the south in the Brandon area, north of Bloomingdale Avenue, east of Bryant Road, on the south side of Knowles Road. The request is for a minor modification to modify the identification of uses within this is a recreational facility that's allow general indoor and outdoor recreational services. They're modifying the site plan to provide greater flexibility on where various approved recreational uses can go, and also clarifying within the conditions the type of recreational uses that are allowed within the permitted use list, including the identified swim pool, that it could also be a wave pool. They're also removing some buildings that were shown in the plan that they're no longer going to construct. Staff is recommending approval, and we're available for any questions. Thank you.
All right, thank you. The applicant here? Good evening, or good morning.
Good morning, Mr. Commissioners. Chris McNeil with McNeil Engineering, 15957 North Fort Avenue in Lutz, on behalf of the applicant. Good morning, everybody. Very nice to see you, and go ahead. It's my honor and privilege to be able to recommend this case to you this morning. This is Heroes Paradise is the existing location. They provide kind of a family fun activity center, which is great for the community. They have several things there that they do: rock climbing, laser tag, archery tag, stuff like that. Some RC stuff. As staff mentioned, it's over south of Brandon. in the central part of the county. The overall area of the site, this is existing conditions. They have several areas of activity around the center there. And this is just a zoom in of the site plan for you to show where the requested wave/surf pool would be located, and that is within the limits of the activity center. The highlighted box there that is on the plan is the main condition change, which includes this to be a 3,000 square foot wave/surf pool, and that is the location, again, within the limits of the multi-use recreation area, which has been clarified as part of this plan. This is just an example of what the surf pool would look like and the activity they're looking to add. And this group focuses mainly on catering to service men and women, their families, but others are allowed to be there as well. So there was one request for administrative variance to a substandard road, and that request has been deemed approvable by the county engineer. I'm available for any questions, should you have any for me. That concludes the presentation. Thank you very much.
Thank you, sir. Anyone here in support of the application? Anyone in opposition? Can we have a motion?
Move approval.
Second.
Motion, Commissioner Wostel, second Commissioner Cohen. Please record your vote on E2.
Motion carried, 7-0.
Next item.
Commissioners, the next item is agenda item E3 is PRS application 24-0917. Commissioners, this is a request for a minor modification of the parcel that's located in the north central part of the county at the Pasco County line, at the west side of Kinnan Street, north of Oak Preserve Boulevard. The request is to add a fourth development option to this plan development. The plan development allows 3 development options, which provides for single-family detached, single-family attached, and multifamily. This request is to add a fourth development option that allows a mixture of single-family detached and multifamily, consisting of 111 single-family detached and 30 multifamilies. No increase in overall permitted maximum entitlements within the project, which is at 143. This will be a 55-plus community. Staff is recommending approval. We're available for any questions. Thank you.
All right, is the applicant here? Good morning, sir.
Good morning, Chairman Hankin, rest of the county commissioners. My name is Brian Sykes, Meridian Partners Law, 4923 West Cypress Street, Tampa, Florida, 33607. You may recall my client actually acquired this property from the county in April of 2023 after the county declared the land to be surplus land. When we acquired the property, it had 2 development options, 143 single-family residential or 143 townhome multifamily single-family residential units. My client is a developer of a successful project located just north of this over the Pasco line called Anand Bihar. It's a 55-plus community. It's currently built out, sold out, and we're actually starting to see resales within the community at this point in time. In creating the community, they wanted to create a lifestyle community. And this property, when it came available, looked like the best option to continue this concept and to bring it to Hillsborough County as well. In December last year, we had a minor modification request to add a 3rd development option. And our 3rd development option was 111 single-family residential homes detached that would be all age restricted. That was approved. We have our certified site plan approved. And as we're looking at the project, we realized that we could offer an additional product type of 30 multifamily residential units by incorporating it into the clubhouse amenity that was proposed for the project. So we've come back with this PRS request to have a 4th development option, which is the option we're intending to proceed with, which would be 111 single-family homes plus 30 multifamily residential units. There would be no material change to the certified site plan with respect to the prior PRS that was approved. And as I said, these 30 units would actually be integrated into the clubhouse. It ended up being a 3-story clubhouse, the top 2 levels being the residential units, the bottom level having the amenities. Just a side note on the amenities, similar to the Anand Bihar project in Pasco County, there'll be a kitchen which will offer 2 meals a day to residents. There'll be meeting rooms, activity center rooms, things like that as well. The project being 55 plus has reduced traffic impacts over development option 1 and development option number 2. Being a 55-plus community, there is little or no impact on the school system. And by staying within our current certified site plan boundaries, we don't have any further effects on any impacts on any environmentally sensitive lands. The project is about 61.87 acres, 38.25 of it is upland. The project is essentially surrounded by wooded areas, environmentally sensitive lands, which provides a natural buffer for the communities that are located to the east and also to the south. We're maintaining one access point on Kinnan Street. And in general, we'll be at 141 total units versus 143, which is originally approved for the project. We're consistent with the underlying NMU for future land use. The entitlements that we're requesting, the multifamily entitlements, were part of the original PD zoning, so we're not requesting anything new. We're just requesting a little bit different combination of things. I'll leave time if there needs to be any rebuttal or if there's any questions.
All right, thank you, sir. That's a public hearing. Anyone in support of the application? Anyone in opposition? Commissioner Wostel?
Thanks. I just wanted to thank the applicant for providing more 55-plus inventory. We really need it. I'll move for approval.
A motion to approve, Commissioner Wostel, second Commissioner Kemp. No comment. Please record your vote.
Motion carried, 7-0.
E4.
Commissioners, next item is E4 CDD 24-1000. Yes. Petition. This is a petition to contract the boundaries of the Pebble Creek Community Development District. This petition is submitted by the Pebble Creek Community Development District and proposes to modify the CDD boundaries to remove approximately 109.41 acres. The area proposed to be removed from the CD is planned to be purchased by the county through the Environmental Land Acquisition and Protection Program. The Pebble Creek CDD was established in May 8th of 2007 and is generally located east of Balm River Road, south of Roding Road, and west of Boyett Road in the Riverview area. No objections were received from reviewing agencies. Staff finds the applicant meets the requirements of Chapter 190 Florida statutes to contract the boundaries of the Community Development District and recommends approval. We're available for any questions. Thank you.
This is a public hearing. Would anyone like to speak this item? Good morning, sir.
Good morning. Bennett Davenport, QTAC Rock, LLP, 107 West College Avenue, Tallahassee, Florida. I believe the matter before you was sufficiently summarized by Mr. Grady, but I'm here to answer any questions if you guys have them.
All right, thank you. Can we have a motion?
So moved.
Second.
Motion, Commissioner Cohen, second Commissioner Wostel. Please record your vote on E4.
Motion carried, 7-0.
Okay. Mr. Grady, F1.
Next item, agenda item F1 is rezoning PD 24-0393. This is a request to rezone a 1.42 acre parcel that's located in the university area on the south between west of Livingston Avenue and north of East Spears Avenue on the south side of Sinclair Hills Road. Again, the request is rezone the 1.42 acre parcel from AS1 to planned development. The request is for 8 townhomes. They would be single-story structures. Again, the parcel currently is developed with a small mobile home park. Based on surrounding uses, the proposed development plan and staff did find this compatible as recommending approval. Planning Commission found it consistent with the comprehensive plan, and the hearing officer also recommended approval. We're available for any questions. Thank you.
Okay, is the applicant here?
Yes, Commissioner, the applicant is virtual. I believe we can put her on WebEx.
Ava, can you hear us? Go ahead.
Can you hear me?
Yes.
Yes. Okay. Hello, my name is Ava Russo. The address is 10009 Gallant Lane, Tampa 33625. I'm an EI working under the responsible charge of PE Michael Hoffman, and I'll be representing the applicant and advanced engineering consultants. We are requesting to rezone the 1.42 acre property from AS1 to a planned development to allow for an 8-unit townhome development. Currently, the property has 7 mobile homes on site, which is under the threshold for Florida Statute 723 mobile home park lot tendencies. The property has a future land use of Res 6, which allows for up to 6 dwelling units per gross acre. The property is proposing 6 dwelling units per gross acre to match the existing conditions. Being that there are only 2 other townhome complexes within a 2-mile radius, we believe this development would be a great addition to this area. The surrounding area is primarily single-family homes with a multifamily development to the east of the subject property. In order to provide compatibility with the surrounding area, a maximum building height of 26 feet is being proposed, which is significantly less than the 50-foot allowable height within the AS1 zoning. Additionally, a compatibility setback will be included for every foot over 20 foot of building height. A type A 10-foot buffer will be provided to the south and east, which is greater than what is required. This buffer will be outside of the townhome lots and therefore maintained by an HOA. Additionally, on-site retention will be provided in areas depicted on the site plan and comply with all county and water management requirements. Per staff recommendations, minor updates to the master plan have been made, which include site data table revisions, additional notes, updates to the exterior lot standards, and a sidewalk connection. Staff has found this development approvable, and we kindly request your approval as well. I will take any questions.
All right, thank you. This is a public hearing. Anyone here in support of the application? Anyone in opposition? Planning Commission?
Thank you, Melissa Lionhard, Planning Commission staff. For the record, the subject property is located within the residential 6 future land use category. The site is in the urban service area, and the subject property is not located within the limits of a community plan. The subject site is in the urban service area where, according to Objective 1 of the future land use element, 80% of the county's growth is to be directed. Policy 1.4 requires that all new developments be compatible with the surrounding area, noting that compatibility does not mean the same as, rather it refers to the sensitivity of development proposals and maintaining the character of existing development. The proposed townhomes are compatible with the existing single-family residential character of the area. The proposal also meets the expected minimum density in accordance with future land use element policy 1.4. The proposal meets the intent of the neighborhood protection policies outlined in the future land use element, including policy direction in the design component. The proposal includes appropriate setbacks and buffers. In addition, the stormwater retention areas proposed within the development serve as a buffer as well. The proposed density and lot sizes are reflective of the surrounding neighborhoods, and the site plan appears to show internal sidewalks and an efficient system of internal circulation with main access off of Sinclair Hills Road and North 20th Street. The comprehensive plan requires that all development meet or exceed land development regulations in Hillsborough County, and at the time of uploading this report, transportation comments were not yet available. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by Development Services. Thank you.
All right, Hearing Master.
The zoning hearing master reviewed the applicant's request to rezone approximately 1.42 acres from AS1 to planned development for the purpose of developing 8 townhomes. The site is currently developed with 7 mobile homes. One person spoke in opposition to the rezoning request during the hearing. The concerns were based on compatibility issues due to the single-family detached homes in the area. The zoning hearing master found that the existing 7 mobile homes being replaced with 8 townhomes will result in minimal impact to the surrounding community. The maximum height for the townhomes is conditioned to be 26 feet, which is significantly less than the 50-foot maximum height permitted by the current AS1 zoning district, and less than the 35-foot maximum height of the adjacent residentially zoned parcels. The applicant's representative stated that the townhomes will comply with the land development code's required additional 2-to-1 setback for buildings over 20 feet in height. The zoning hearing master concluded that the rezoning to plan development for the development of 8 townhomes is consistent with the land development code and the comprehensive plan, and the zoning hearing master therefore recommended approval.
All right, can we have a motion?
Move approval.
Second.
Motion, Commissioner Kemp, second, Commissioner Wostel. Please record your vote on F1.
Motion carried, 7-0.
All right, next item.
Commissioners, next item is related items G1A and G1B. G1A is a modification to the DRI, Sable Center DRI, application number 24-0030. The purpose of this modification will be to modify the DRI development order to established for this portion of the projects that's being modified, trade-off metrics to trade-off approved uses, which in this area, which considered hotel, retail, multi-office, and industrial uses, adding multifamily to that use list and allow for all those be traded off based on a trip maximum concerning peak trips and daily trips. The multifamily, which is being added, will be subject to mobility fees as part of this. They're also modifying the build-out date for the DRI. The rezoning application, G1B, this is for a major modification to the plan development associated with the DRI. The portion that's being modified is located at the quadrant of south of Martin Luther King Boulevard, east of Falkenberg Road, north of Broadway Avenue, and west of I-75. The major modification for this area will add as an allowable use within this portion of the PD, multifamily. Multifamily is already allowed within this PD in the area north of Martin Luther King Boulevard. So we'll be adding it to this portion of it. They're also requesting a building height increase to 60 feet from 39 feet for the multifamily, and also requesting that the allowed commercial uses be allowed. Right now, they're limited. Standalone retail is limited to Pod 3 within the project, and accessory retail elsewhere within that portion of the PD. This request would allow them to have standalone retail throughout that portion of the development as part of this modification. Staff did find this request compatible with surrounding development pattern, and the Planning Commission found it consistent with the comprehensive plan, and the hearing also recommended approval, and staff's available for questions on both G1A and G1B.
Okay. This will be a combined public hearing. Is the applicant here? Good morning, sir.
Good morning, Commissioners. Ken Tinkler with Carlton Fields Law Firm, 4221 West Boy Scout Boulevard, representing Citigroup Technology Incorporated. With me today is also Shelby Fuente, who's a planner for Stantec Engineering, and we have been sworn. Brian did an excellent job outlining the request here. I just wanted to give a little bit of context. This is Citigroup's primary campus here in Hillsborough County. There's thousands of employees who work here every day, and several dozen different city business divisions call this home. When the DRI was first approved decades ago, it did allow for many uses. We're looking to update it a little bit to allow for multifamily and allow some flexibility among the pods within the development. The update to the development build-out date is based upon the statutory extensions that have been granted. So this build-out date is already in place. You're simply adding it to the development order at this point. We are here for any questions, given it's a combined hearing, but I'll stop there. Thank you all.
Thank you, sir. Anyone here to support the application? Anyone in opposition? Commissioner Wostel?
Thank you. Are the apartments going to be restricted to Citigroup employees? Is that the intent?
Citigroup would not be the one building any apartments.
Okay.
It's just to have the ability of having that extra use.
Okay.
But the idea is to have a full mix of uses, given the sheer number of employees they have there.
Okay. If it was that Tampa General's trying the same thing, it seems to be a direction the industry's going, and it would be a significant traffic reducer if people that worked lived right next to where they work, like in a situation like this. So I'll move for approval.
Second.
We've got a motion to approve both G1A and G1B. Commissioner Wostel, second Commissioner Kemp. And I agree with Commissioner Wostel. I think this is a model that's going to be utilized more and more in the future. And I've spoken here several times over the last 2 decades. A wonderful campus. I've got a motion, a second. Please record your vote.
Motion carried, 7-0.
Okay. Next item.
Next item, we've related items G2A and G2B. These will be separate votes on these because G2B is a CDD application, and it's unrelated because the CDD cannot proceed until board acts on the rezoning application, which is G2A. So G2A is rezoning petition 24-0044. This is for rezoning of a plan development previously approved in 2019 for 1,047 units. They're adding in an additional 55 acres in order to incorporate another 110 units within the PD. This project is located in the Waimama Community Plan area east of US 301. The area being added, the 55 acres being added to the project, and also the area where they're transferring units on the western part of the PD, was reviewed for compliance with the Waimama Community Plan development standards that were adopted subsequent to the original zoning approval in 2019. As part of that, they are required to meet community benefits requirements, including additional open space. They provided reserved an area for a potential fire station site, and of providing for a multi-use trail crossing 301 to connect to a trailhead within the Little Manatee River State Park. Staff did review it against compliance with the development standards of the Waimama Community Development District, and we are recommending approval. Planning Commission found it consistent with the comprehensive plan, and the hearing officer recommended approval. We're available for any questions on item G2A.
All right, is the applicant here?
Good morning, Cammie Corbett with the law firm of Hill, Ward and Henderson, representing the applicant this morning. Brian covered everything I was going to cover. It's pretty straightforward. I do have one quick graphic that will illustrate for you a little more clearly where the property is being added. So the property in red is being added, so it's the property to the north, and the pod where the fire station will be is here in that northern pod for Pod A. We did hold 2 community meetings for this application and did receive input from the community on this. And we're here to answer any question. Our planner is here. Our transportation consultant is also here.
Okay. Any proponent testimony? Anyone in opposition? Planning Commission?
Thank you, Melissa Leinhardt, Planning Commission staff. The subject property is located in the Waimama Village Residential 2 Future Land Use category. The site is in the rural area, and the subject property is also located within the limits of the Waimama Community Plan and the South Shore Area-Wide Systems Plan. The proposal is consistent with Future Land Use Element Objective 16 and its accompanying policies related to neighborhood protection, as the request for additional residential units is compatible with the surrounding residential development pattern. Policy 16.7 requires that neighborhoods shall be designed to include an efficient system of internal circulation and street stub-outs to connect adjacent neighborhoods together. The site plan depicts several stub-out streets to the east, west, and south. The site plan also shows a connection to Bonita Drive, allowing an opportunity to connect to the north. This meets the intent of Future Land Use Element Policy 48.10, which requires new development to accommodate the street network through grid-like patterns as represented in the comprehensive plan and as pertains in Waimama. The proposed addition to the existing Berry Bay development is approximately 55 acres. Therefore, per Objective 48.7, at least 3 community benefits must be provided. There are 3 that are proposed, which meets this criteria. The proposed open space community benefit meets the criteria established as a Tier 2-7, as it provides at least a 35% increase in internal open space and a 25% increase in recreation. The second proposed community benefit is a crosswalk and connection to Little Manatee River State Park, which furthers connectivity goals in the Waimama Village Community Plan. The third proposed community benefit is for 2 acres of land to be set aside and used as a civic lot or fire station within Pod A as depicted on the site plan. A fire station is a residential support use that is compatible with the surrounding development pattern. Civic uses such as fire stations require acceptance of land dedication from Hillsborough County. Goal 6 of the Waimama Village Community Plan seeks to ensure a balanced transportation system that connects new streets with existing streets to provide multiple north, south, and east-west connections. The connection to Bonita Drive supports this goal. Goal 9 of the community plan further establishes that a maximum density of 2 dwelling units per gross acre shall only be considered if the request is consistent with the comprehensive plan and the land development code. The request meets this community benefit requirement. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by Development Services. Thank you.
Thank you. Hearing Master.
The zoning hearing master considered the applicant's request for rezoning of 646.95 acres from agricultural rural to planned development, or agricultural rural, and plan development to a new plan development. The existing plan development, 19-102, is currently approved for 1,047 dwelling units and a school site and public use facility under 2 development options. The project consists of 2 non-contiguous development areas with density transferred from the sending area, the Bullfrog Creek mitigation area, to the receiving area, Berry Bay. The rezoning proposes to add 55 acres to the planned development and 110 additional dwelling units for a total of 1,157 dwelling units. The request also proposes to eliminate one of the development options, including the requirement for the public school. The project will be subject to the revised Wamama Village regulations, which include community benefits that will be satisfied by the development of a fire station, an increase in the percentage of internal open space and recreational space, and a crosswalk which will link the existing multi-use paths to the Little Manatee State Park Trail. The ZHM's report concluded that the vast majority of the subject property is currently approved for 1,047 dwelling units. The addition of 55 acres and 110 dwelling units, which will comply with the Waimama Village Residential 2 regulations, including community benefits, will result in a project that is compatible with the area. It is emphasized that the existing development will comply with the previously approved Waimama Village Residential 2 requirements, including employment opportunities. The zoning hearing master concluded with a recommendation of approval.
Commissioner Wilstrom.
Thank you, Mr. Chair. I had a couple of folks reach out to me asking me not to approve the 1,050 units that are on this lot, and I just wanted to point out to them that that PD 19 means that they were entitled in 2019, so that's not something I could undo for them. Thank you very much.
Okay, we'll defer vote until after G2B. Staff need to make any comments on G2B?
Yes, Commissioners, the next item is agenda item 2. G2B CDD 24-0559. This is a petition to expand the Berry Bay Community Development District. As discussed, this is related to the prior item to add in the areas associated with the areas being added to the PD, to add them to the CDD. The areas being added to the CDD are located or identified in this graphic with the numbered yellow highlighted parcels. Staff has found this application meets the requirements of Chapter 190 Florida statutes for the staff to expand the community development district and recommends approval. Thank you.
Applicant, come up. Good morning, sir.
Good morning. Brian Lamb with Infomark, authorized agent for the Berry Bay Community Development District. Here today to answer any questions, recognizing that staff did a thorough job and overview as it relates to some of the details associated with the expansion as proposed today.
Thank you, sir. Anyone here in support of the application? Anyone in opposition? All right, can we have a motion for both G2A and G2B?
Move for approval.
Motion, Commissioner Myers. Second Commissioner Wolstel and Cohen for G2A and G2B. Please record your vote.
Motion carried 7-0.
All right, last item.
Commissioners, the last item is I-1. It's status report on Live Local Act development projects. As per board direction, every board meeting we are providing a status update on applications received since the last board meeting. As the board is aware, at the last board meeting, the board did proceed with zoning in progress, prohibiting further processing of any Live Local requests we received for plan developments. We did receive 3 new requests, but they were all in standard zoning districts, and the table and a map within the staff report backup lists those additional 3 parcels that were received since the last board meeting. And we're available for if you have any questions or comments.
Any questions or comments from board members? Okay, none, we're adjourned.
I'm
Yes, Commissioner
sorry. It went so fast, I wasn't expecting that. I just want to thank staff, I think that they did a great job in putting that chart together. I had it, I have it at home. I was looking through it and everything, and I just had asked, and they've already said that they would do that, just to make a distinction there between the urban service area and the rural service area and where these developments are. I think it's really great just to see the progress and to let us know what's in the what's been applied for and how it's working. So I really think that that's good. And I'd just like to note for the record, there's only one now that's in the rural service area or outside the urban service area on Van Dyke, correct?
That's correct. That's the one we have, yes.
Okay, thank you.
Okay, I don't see anyone else in the queue, so we're adjourned.